Hi, everyone. Thank you for joining us today. I'm Marche, the webinar director at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own. And however, true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we're thrilled to bring you this educational presentation. Attendees are muted, but we encourage you to ask questions using the chat box. We'll field as many of those queries during or after the webinar today as appropriate. And if you ask a question in the chat box and we haven't had a chance to get to it, go ahead and leave your phone number as well. If we can't get to your question during the event, we'll make sure someone reaches you after today. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. I'd love to introduce you to today's moderator. Joe Dallow is an accredited investment fiduciary with Dallow Financial. He enjoys serving his clients and helping them plan for the future. He and our guest speaker, Scott, both earned their law degrees from the Thomas M. Cooley Law School at Western Michigan University. And Joe, I'll just have you go ahead and say hello in a few words.
Yeah. Hi, everyone. Thank you for having me on here, Marche. And we're going to be talking about elder care law and with a very special guest, Scott. Scott and I went to law school together. And wow, that was like such a long time ago. I think it was maybe we started about 14 years ago or so. But this is a very important topic, and I feel like people should know more about elder care law, and Scott is the man to talk to about that.
Well, I'd love to introduce our guest speaker today. Scott Robbins is a partner at Barron, Rosenberg, Mayoris, and Mayoris. He concentrates his practice in estate planning, elder law, Medicaid planning, veterans benefits, guardianships and conservatorships, and special needs planning. Selected as a rising star by Super Lawyers magazine, that has been since 2018 to 2019 and 2020, and hopefully 2021, right, Scott? And he has also been recognized as Best Lawyers in America, Ones to Watch. And we're excited to have you both here. I know that we have discussed how we're going to run this. I'm just going to go ahead and put our disclaimer up here. I believe that we're going to have Joe lead us in our presentation, and then Scott, we have some expertise here, and we're excited to hear from you.
Thank you.
Yeah, so Scott, what is the difference between estate planning and elder law?
Well, the two are very close. They're interrelated but distinct from each other. Estate planning is the creation of various documents like powers of attorney, wills, trusts, or deeds to address the best way that assets can be managed or distributed when a person becomes ill or passes away. Elder law takes things to the next level. It's designed to allow those managers the ability to stretch the funds so that an individual and his or her spouse can receive the greatest quality of care in the least restrictive setting and at the least cost to themselves and to their family. It might be best to think of elder law like estate planning with a detailed focus on preservation. Elder law isn't necessarily a different set of documents from an estate plan, but a different strategy and terminology within the estate plan itself.
So when is the best time to start thinking about elder law plans?
Let me answer your question with a question. Does somebody fasten their seatbelt before or after they get into an accident? The obvious question should be before. The same goes here. Whether it's basic estate planning or elder law, you need to have the documents established before you need them. Otherwise, it's too late. A person has to have the capacity to understand the document that they're signing and to understand the power that they're giving to their entrusted agents. If a person without documents has lost the ability to implement them, the only way to get the needed authority is to petition the court. And I like to avoid going to court if it's possible. The reality is that many people miss their opportunity. So we find ourselves going to court often to ask the court to permit us to do what could have been granted by the individual himself or herself. The risk when we go to court is that the court can say no. And because some of this planning puts a lot of trust and faith in the people that are executing those plans for us, the court is sometimes reluctant to grant those same permissions, which we would have or could have granted ourselves.
Okay, so what are the most important documents when addressing elder law issues?
Most of the time, it's going to be the powers of attorney, specifically a general durable power of attorney or a DPOA. The will, the trust, patient advocate designations that address health issues are all very important. But for me, the DPOA allows an appointed agent to restructure the financial components to change either the countability or non-countability of assets. And I'm often consulted after a person has developed the need for very high levels of care. And if the DPOA is drafted appropriately, I can help get that person the care that they need at very little or sometimes even no cost to themselves. The money that's been saved can then be used to supplement their own care or provide additional support to that person's spouse.
Okay, so if someone already has documents in place, do they need to replace them?
Maybe, but it's really tough to say without seeing them. It's extremely important to realize that not all documents are created the same. The various estate planning documents don't need to meet many criteria in order to be valid versions. For example, a trust, powers of attorney, wills. But if the language within those documents is insufficient, the authority that's needed isn't there, even though the document might be valid. Because of this increased risk associated with certain actions that we take in implementing elder law plans, the laws require that in order for a document to be permitting of those actions, it needs to be specifically mentioned and permitted within those documents. Otherwise, those actions are strictly prohibited. I frequently encounter, unfortunately, documents that don't allow for the needed actions. And so in those situations, our only option is to seek a court's authority. And I already explained that sometimes that court authority can be difficult to obtain.
Okay, so can someone just give away assets to qualify for public assistance?
Absolutely not. That could be one of the biggest mistakes that a person makes. All of the public benefit programs have rules that penalize giving assets away. Remember, these programs are designed to aid those in need. If giving assets away allowed somebody to qualify, everyone would give away everything they have at the moment that they need care, and all the programs would fail. The idea is that if a person has available resources, they're going to be expected to use those resources, and then when they run out, the public programs would kick in.
Can the Medicaid program take my assets?
Although it's very commonly believed that the Medicaid program might be able to take somebody's assets, the short answer is no. The Medicaid program will never take a person's assets, but they can refuse to provide benefits if a person has resources to pay for their own care. Some people might view this as being the same, but it's really very different. The Medicaid program evaluates a person and their assets to determine if they qualify for their benefit programs. When it comes to assets, an individual is deemed eligible if they have countable resources below $2,000. It's important to understand that not all assets are considered countable resources. Generally, things like personal property, which is clothing, artwork, jewelry, furniture, a vehicle, a home, a burial plot, and prepaid funeral plans, in addition to some life insurance policies, are all going to be considered non-countable, and they don't get added to a person's total. While most people are concerned with assets related to Medicaid eligibility, it's also important to realize the connection between those assets and the Medicaid program when they pass away. If any assets require a probate court administration at a person's passing, the Medicaid program is deemed a creditor who can file a claim and collect the full value of those benefits that they've paid on someone's behalf while they were alive. That could very easily consume all of the value passing through the probate estate, especially considering that the average cost of a nursing home is $9,560 per month in the year 2021. Just to give you an example, imagine that a person receives a Medicaid benefit with an exempt home worth about $250,000, and they receive that benefit for 2.5 years before they pass away. When they die, their home would likely go through probate, and the Medicaid program would be able to file a claim for $287,000. That's equivalent to 30 months at that monthly average of $9,560. Without any planning, Medicaid would be able to recover the full value of the home. And there are ways to save it, which is where consulting with an elder lawyer is beneficial.
And Joe, we did have a question come in. Do you want to go ahead and ask that?
Yeah. Is land outside of a home a countable asset?
If it's immediately connected to the home, it's going to be considered part of the same. And there are some limitations with regards to real estate. So we'd have to look at the specific situation to say whether or not it is countable or non-countable, being excluded. If it's a second home, if it's other vacant property, if it was a timeshare or something like that, it very likely may be separate and countable. So it's going to depend on the exact circumstance, but generally an individual home and the land attached to it is going to be treated as exempt.
And then maybe you can speak to this. Every state is different. And I know that you are licensed in the state of Michigan, but maybe you can speak to that really quickly.
So yes, I'm licensed in the state of Michigan. My knowledge is very much limited to the state of Michigan. And so if somebody's in a different state, what I would always encourage them to do is consult with an elder law attorney in that state. The strategies are all different because the rules regarding these types of benefits are going to be different, as the programs themselves are funded federally, but each state is allowed to design the rules for their plan within very specific limitations. And so any other state might have strategies which would be better or worse, but usually a little bit different at the very least from the strategies or laws that are applicable here.
Thank you. And once again, to our participants, go ahead and ask your questions in the chat. We'll fill that as best we can during the presentation.
Okay, so Scott, how can someone protect their assets from being spent down to zero?
The short answer, of course, is to consult with an elder law attorney. The long answer is that there are several strategies, all of which have their appropriate times and places to implement depending on the many specific circumstances of that individual's needs. There's too many to go through right now, and they're extremely complex. So it would be overload to cover all of them anyways. Plus, the rules are constantly changing, which causes the strategies to change constantly too. A strategy might exist today that might be different or non-existent later, or a new strategy may arise. The best place to start, though, is with proactive planning through the establishment of an estate plan that allows for the implementation of elder law planning. With that in place, the appointed agents can rearrange those assets, modify the existing plan, or even create new trusts so that otherwise unprotected assets can be preserved so that that individual or their families, including spouses, can receive the benefits before reducing their assets to zero. It's critical to understand that although Medicaid provides a significant benefit, it doesn't cover absolutely everything. And so preserving resources not only provides access to funds for supplementary care, but could potentially preserve a legacy to family members if there's anything left. In some situations, necessary protection can only come from probate court, and there's no other option. And although we've been very successful at getting the court's authority at times, there's other times when the court's relief is a second or third option because there are no guarantees. Each of the strategies is based on the laws of program eligibility, and it uses them in the most advantageous way, similar to somebody taking advantage of a tax code to qualify for a tax credit or a rebate.
Okay, what might a typical plan look like for a single individual?
Well, consider the following facts. Let's say we've got a 72-year-old single individual who needs skilled nursing care. They have a house worth about $200,000. They have $25,000 in the bank, a non-retirement, stock account worth $250,000, and an IRA worth $100,000. That totals $575,000 or $375,000 plus a home. Let's also assume that that person receives $2,100 per month between their Social Security and pension. First, if we do no planning, the home is generally going to be an excluded asset. So if we deem that safe, the remaining $375,000 would last approximately 39 months at the $9,560 per month average for the nursing home care. They would then be out of resources and be eligible for the program. But like I said before, the Medicaid program doesn't cover absolutely everything. So what if they need additional care, supplementary care? Would they be able to rely on family to provide that support? Another problem is related to the house. Even though it's safe, how do we pay for the home's upkeep? Things like taxes, insurance, if all the other assets have been spent to zero. By implementing an appropriate plan, not only will the home be saved, but approximately $210,000 of that $375,000 can be protected. So the saved resources can provide for any other supplemental needs that the person needs, which aren't covered by the Medicaid program, and also maintain the home and keep it in good shape. The total amount saved would be right around $410,000, which is equal to 72% of that starting value of the person's assets.
And what might a typical plan look like for a married couple?
Well, consider these facts. Let's say we have a 74-year-old who needs skilled nursing care, and they have a 72-year-old spouse. They also own a home estimated at $250,000. They have $25,000 in the bank, non-retirement accounts worth $185,000, and an IRA worth $175,000. This totals $635,000 or $385,000 plus their home. What happens if we do no planning? Well, the rules regarding married couples is a little bit different from single individuals. And so the home would be protected as well as $130,000 roughly of the assets to be allocated to the spouse. So the remaining $255,000 would last right around 26 months at that $9,560 per month expense. The spouse would be able to live in the home and they'd have $130,000 to cover their expenses, among other things, but they aren't left with a whole lot to spend for the rest of their life. And it's unlikely that they'll be able to supplement their nursing home spouse if there's additional needs. But what happens if that spouse who's living at home then spends their assets to zero? With appropriate planning, it's actually possible to protect the home and all of the assets. So the well spouse, the spouse living at home, would not only have the home, but they'd have $385,000 to cover their needs. And it would be more likely that they'd be able to provide supplemental support to their nursing home spouse, in addition to being able to support their home. Now, this strategy would require the court's protections, but it's something that we do often, and we have been very successful in doing that.
And Scott, is this planning legal?
Yes.
Before that, you said that in this case, you would need permission from the court, or you need the court's protection. What
Yes.
exactly are you referring to? Just a special case in this example?
So when it relates to a married couple and one of them needing a high level of care, the Medicaid benefits will allocate a certain amount of those resources to the spouse that's staying in the home. And like I was mentioning in that example, I was using the number 130,000. That number is going to fluctuate, and it's not exactly 130,000, but we can use that as our example. There are some rules that create a few different scenarios to determine exactly what is going to be protected. And so one of the rules actually indicates that if a court has issued an order allocating a certain amount of resources between spouses, then the amount that's ordered is the amount that's deemed protected. So in the case where we implement the planning, what we would actually do is petition the probate court to issue a protective order to allocate the assets of the two spouses to one of them. And then we would use that order when applying for the Medicaid benefit. And the Medicaid program would have to take that order into consideration, and they would have to essentially look past those assets because they would be deemed protected according to the rules.
Right, thank you. That was a complicated answer, but I, like you said, the answers are complicated.
Certainly.
Okay, so Scott, is this type of planning legal?
So the answer is yes. Even though people typically don't think it is, they don't know that it may be available. And it's also very difficult to understand actually how we implement these plans. It is legal. As I talked about before, it's similar to taking advantage of one tax code provision versus another, or recategorizing assets so that they fit within the benefits program framework in a more advantageous way. The program is not designed with these strategies in mind, but smart minds have figured out a way to operate within the parameters of the rules to get a better outcome. The programs that provide these benefits, though, are constantly working to close those loops, which is why the landscape is constantly changing, as are the strategies.
Okay, awesome. So I have a couple of questions from the audience, and we can ask these. I'll ask you a couple of them that we have.
Sure.
So if someone already has documents, for example, a will and a power of attorney, can documents be easily revised to include the permissions that you mentioned?
Yes. And so what we would usually do, depending on the document, is either make an update to it, or we could simply replace it. Usually, wills and powers of attorney are shorter in length, and they're more simplified by creating new versions than by modifying. Because when we have modifications, we have to take both the original document and the modification, interpret them together. So oftentimes we will simply replace the document so that it's more straightforward when it's being used going forward. There are some circumstances where somebody can create documents, specifically certain types of trusts, which are not able to be changed. However, in those situations where it can actually cause some sort of harm, or the circumstances which existed when we created them were different from the way that the future actually played out, there are options to go to court to have those documents either modified or terminated so that we can move forward with a more appropriate plan and get the relief that we're looking to achieve.
Okay, so you spoke about going to court. How long might it take to go to court to get the permissions to make the actions to protect the assets like you suggested? I know there's a range, but if you can kind of.
So it's always going to depend on what the request is, because some requests are a little bit more simplified, other requests are a little bit more complex. So there's going to be some time where it takes us time to put together our petition or our request to the court. Once we file it with the court, there's going to be some range that's going to be based on a number of circumstances where the court will schedule a hearing. We've got to notify all of the interested persons. And once we get to that hearing, we can ask the court for our relief. Generally, I would say it's probably going to be about 3 to 6 weeks from the moment that we actually get our petition processed. Right now, it's maybe an extra 2 weeks or so on the higher end, just because we are operating through the mail with the coronavirus pandemic. And so the courts are operating remotely in a lot of instances, and some of their capacities are reduced. So it's a little bit more up in the air with regards to the court's timing, but generally I would expect something a month plus or minus a few weeks.
Okay. And how does elder law fit in with estate planning? Does my financial planner need to consult with an elder lawyer?
So again, the elder law planning is more of a specialty or a subset of estate planning. And so, was that the question? Sorry. Yeah.
I believe so. Yes.
Yeah.
Okay. So the elder law plan exists within the estate plan. And so any estate plan could have elder law provisions, whether it was intended from the start or not. But it's going to be determined by the actual text of those estate planning documents. And so I would always ask somebody, if I was meeting with them, to share their existing plan with me so we could see what it says, to see whether or not something is permitted, prohibited, or it's just silent. In certain circumstances, the powers that we need to execute or we need to use in order to achieve the relief that we're looking for is sometimes so risky to the individual who is giving that authority that it needs to be specifically stated within the documents. Otherwise, the power is prohibited by the statutes.
Okay. And then I have a couple more questions. These
Sure.
two kind of go hand in hand, so I'll ask you them together. How often do you have to update your legal documents? And if you move to a different state, do you have to change all of your legal documents?
So updating documents is something that people will do for a number of different reasons. I always tell people to, at least on their own, review their own documents every few years, because it's very easy to forget. I even do this myself. Exactly who you selected as your various agents, or how you expressed your wishes regarding the disposition at your passing, or how things are to be managed if you become incapacitated. It's difficult to remember all the provisions. A complete estate plan has several different documents, and so remembering all those details is tough. So at the very least, if the individual pulls their binder off the shelf every once in a while and just reads through on their own, I think there will be a good opportunity to identify areas within those documents where they feel that something needs to be updated. There's also going to be a lot of language that they won't understand, because there's complex legal issues, there's tax issues, and a lot of complex language that is sometimes very difficult to understand. So every few years, it's probably a good idea to reach out to an attorney to at least have that attorney look through the documents and see whether or not the plan is in line with the current statutes and the current estate planning landscape. At a minimum, I would probably say every 5 years, but you might be able to get away with a little bit longer than that. It doesn't necessarily mean, though, that just because you're reviewing it every few or even 5 years with an attorney that you have to update things. If you move to a different state, I would definitely have an attorney in that new state look at the documents, because even though they're probably going to be valid, and I say that because in Michigan, if you moved here from another state, the state of Michigan has statutes that say that as long as the documents were valid somewhere else in another state, Michigan will treat them as being valid documents. But like I've been mentioning, certain actions require specific authorization. And so even though the document's valid and it doesn't need to state a whole lot in order to be valid, there might be certain things that need to be addressed here in this state, or if you move from here to another state in the other state, that without mentioning it could limit the authority and beneficial use of those documents. So if you move, I would definitely have them looked at. If you are traveling, I don't think that you need to worry about preparing some new documents, but I would definitely have a copy, with you.
Okay, and then what are the most common misconceptions people have about elder care law?
I would say that the biggest misconception is that the benefit programs are exclusively available to people with no money. The programs themselves are designed to provide benefits when an individual has a low threshold of assets, but it doesn't mean that every asset is countable. So there are ways to make assets appear or disappear from the balance sheet so that a person meets the criteria, that according to the rules, doesn't have the resources above the limit in order to qualify. So there are ways to qualify for benefits. Another thing that is misconceived is that the public programs require a person to accept some substandard level of care. Usually when I'm talking about Medicaid benefits with individuals, they believe that in order to receive those benefits, they have to be in a nursing home that is dirty and dingy and doesn't receive good care. And that's just not the case. There are nursing homes all over the state in some of the greatest areas that provide very good levels of care. And some of those places are fully 100% Medicaid certified. What people don't realize is that the cost, the monthly cost, can be upwards of, the average is $9,560, but it can be $10,000, $11,000 or more. And there could be one person in a nursing home bed who is able to pay for it and is paying directly out of pocket. And the person directly in the room next to them is receiving the exact same level of care, but receiving the Medicaid benefit at either zero or very little cost to themselves. And I would say that that's probably the biggest misconception.
Okay. And can you speak a little bit about how trusts relate to elder law?
Yes, trust relate to elder law because it's one of the tools that we would implement in setting up the plan. And it can be, again, in a handful of different scenarios. There's a whole bunch of different types of trusts, whether there's revocable trusts, irrevocable trusts, children's trusts, joint trusts, single trusts. And so we use them as tools because a trust can be viewed like a middleman to hold assets, to manage assets, to distribute assets. And it's oftentimes the safest place to house a resource while we're waiting for something else to happen.
Okay.
I actually thought of, sorry to cut you off if you were about to say something.
No.
Another misconception that people typically have is that elder law is for old people. The name definitely suggests it, but we actually will often reference that elder law is for anybody who wants to be old one day. And you never know when there could be some circumstance in somebody's life where they do need a higher level of care. Statistically, it does apply to elderly individuals, but as time goes on, we encounter younger and younger individuals who have a higher level of care or require a higher level of care. And so having the appropriate documents isn't something that I recommend somebody implement once they reach 40, 50, 60, 70. It's something that if you're going to implement a plan, you're best suited implementing the plan with those provisions when you implement it. I myself am in my mid 30s, mid to upper 30s, and my plan that I've had for quite a while has always contained elder law provisions, even though my hope, my belief is that I'm not going to be using them for a long time.
Awesome. I think that I've gone through all the
Yeah.
questions. Maybe Marche, can you help out?
Yes, if we have some more questions, we have reached the end of our time today. And if we have some more questions, go ahead and leave those in the chat with your number. We'll try to reach out to you if we don't have a chance to, since we don't have any more time to address those. And first of all, I want to thank Joe and Scott. Thank you so much for being here today. Thank you to our attendees for attending. It says a lot that you're interested in learning about this topic, and thank you for being proactive for yourself or for your loved ones. So look for an email soon with a replay to this event, and you're welcome to share that replay with friends or family. Here at Advice Chaser, we're all about helping you find a financial who is a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. So find out more by going to advicechaser.com. Click on the link that says Find an Advisor. Once again, thank you from Advice Chaser, and we will see you at another webinar soon. Bye, everyone.